students, welcome to GNANA DEEKSHA concept-based digital learning on the theme Essential Elements of a Valid Contract. I am Mrs. Neha, Tunk, working as a degree lecturer in commerce at Telangana Social Welfare Residential Degree College for Women, LB Nagar. Let me start the topic with an interesting story of Emperor Akbar and his intelligent minister Birbal. One day, Akbar and Birbal were walking on the riverside. Just then, a farmer and his neighbor came up to them with a complaint. The farmer fell on Akbar's feet and said, "Your Majesty, I bought a well from this man, and now he wants me to pay for the water." "That's right, Your Highness," said the neighbor. "I sold him the well, not the water in it." The argument confused the emperor. Birbal was to resolve this conflict. Birbal was calm and composed. He smiled and said, "Good, but look, since you have sold the well and you claim that water is yours, then you have no right to keep your water in the farmer's well. Either you pay the rent to the farmer to keep your water in his well, or you take the water out of his well immediately." The man understood that his trick has failed. This way, the farmer got justice. During ancient times, the traders approached their rulers for justice over breach of contracts. The fundamentals of law of contract have been in existence since the time of ancient India, and in fact, they were well recognized. In ancient India, in ancient times, the law of contract was based on the principles of truth. It was considered to be the duty of the king to ensure that the persons performing the agreement entered by them. In a way, it has been the effort of mankind that the promises made by men are fulfilled. Keeping this as base, the law of contract is precisely to ensure that promises made are fulfilled. The primary objective of law of contract is to identify the circumstances where the promises made by the parties to the contract become legally binding on them. In today's lecture, we are going to learn about Indian Contract Act 1872, its broad objectives, its definitions, and the essential elements of a valid contract. Now let's begin with the evolution of Indian Contract Act. The law related to the contracts was dealt with the charter granted in 1726 by King George I to the East India Company. Thereafter, in the year 1781, the Act of Settlement was passed by the British government. The Act of Settlement authorized the Supreme Court of India to deal with all the matters of contract between parties. In spite of changes made by the statute, there were a number of complications relating to the laws concerning contracts. Therefore, in the year 1861, the Third Law Commission of British India, under the chairmanship of Sir John Romilly, presented the report on contract law for India. The Law Commission submitted the draft on 28 July 1866. The draft contract law, after several amendments, was then enacted, and then Indian Contract Act came into force. This was with effect from 1st September 1872. This extends to the whole of India except the state of Jammu and Kashmir. The law of contracts does not enforce certain rights and duties of the parties to the contract. Instead, it specifies certain limits within which the parties can create their own terms and conditions for the contract. Therefore, the parties to the contract create their own rules of contract, provided they do not infringe the legal prohibitions. Now let's learn the need and objective of the law of contract. In a nutshell, the objective of law of contract is to identify true intention of the parties to contract, to define promises made by them towards one another, and to make such promises legally binding on them. There are several definitions of a contract. Let's discuss some of the prominent ones. According to Sir Frederick Pollock, every agreement and promise enforceable at law is a contract. According to Salmond, a contract is an agreement creating and defining obligations between the parties. According to Section 2H of Indian Contract Act 1872, a contract is an agreement which is enforceable by law. Now, having said that, let us see what a contract is. Now, what is a contract? You must have heard this word contract in your day-to-day life. For example, when you go to purchase goods in a mall, it's a contract. When you buy a car at a showroom, it's again a contract. When you book a ticket at a cinema hall theatre, it's again a contract. When you buy a land or a flat, it's again a contract. To understand this, first, let's have an understanding as to what a proposal and promise is. Now, what is a proposal? A proposal is when one person gives an offer to the other person. For example, A promises to sell a car to B at a certain price. Now we call this as an offer or a proposal. Now let's see and understand what a promise is. When a promise or a proposal or an offer which is accepted by the other party, it becomes a promise. Here in our example, if B accepts to buy the car at certain price from A, it becomes a promise. The person making the offer or proposal is referred to as promiser. And the person who accepts an offer is referred to as promisee. We also call them as offerer and acceptor. Now that we have learnt what a proposal and promise is, let's further see what an agreement is. When both the parties exchange promises, it becomes an agreement. So, offer plus acceptance is agreement. An agreement, if backed by legal enforceability of law, converts to a contract. Hence, we can say that agreement plus enforceability at law is contract. Now let's see what are unenforceable agreements. Unenforceable agreements are domestic agreements, social agreements, and void agreements. We will learn each of these in the further slides. Let's see what are the essential elements of a valid contract. Section 10 of Indian Contract Act 1872 reads, all agreements are contracts if they are made by free consent of the parties competent to contract for a lawful consideration and with a lawful object, and are not hereby expressly declared to be void. In simple words, all the essential elements of a valid contract must exist in the agreement in order to constitute a valid contract. Now let's see what are the essential elements explained under section 10 of the Act. The very first one is legal offer and legal acceptance. Intention to create legal responsibility is also one of the essential elements of a valid contract. Similarly, lawful consideration, competency of parties, free consent, lawful object, certainty, possibility of performance, legal formalities, and agreements not declared as void. Now, all these are the essential elements which constitute a valid contract. Now, let's discuss each one in detail. Legal offer and legal acceptance. In order to create a valid contract, it is necessary that there must be at least two parties, one the offerer and the other the acceptor or the party who is accepting it. The law has prescribed certain rules for making the offer and its acceptance that must be satisfied while entering into an agreement. For example, the offer must be definite and duly communicated to the other party. Similarly, the acceptance must be unconditional and communicated to the offerer in the prescribed mode. Now let's see what the next essential element is. The next essential element is intention to create legal relationship. The intention of the parties to contract must be to create a legal relationship between them. Agreements of social nature do not contemplate legal relationship. Thus, they are not contracts at all. For instance, if a father fails to give his daughter the promised pocket money, the daughter cannot sue the father because it was purely a domestic agreement. Thus, it is clear that all agreements which do not result in legal relationship are not contracts. Now, let's see some other examples. In an invitation to dinner, there is no intention to create legal relationship with the other person, as it is a mere dinner party, and therefore it is not a contract. Similarly, certain agreements between husband and wife, they do not become contracts because there is no intention to create any legal relationship. You can see Mr. and Mrs. Balfour on the slide. The leading case of Balfour versus Balfour is a well-known illustration of this principle. Mr. and Mrs. Balfour were enjoying their leave in England when they had to return to Ceylon, where Mr. Balfour was employed. Mrs. Balfour was advised to remain in England due to her ill health. Mr. Balfour returned to Ceylon and agreed to send a certain sum of money, that is £30 per month, for meeting her day-to-day expenses. After some time, there were few differences which arose between them. And Mr. Balfour stopped sending the money. Mrs. Balfour filed a case against her husband for allowances. The court held that Mr. Balfour was not liable for the expense, as it was merely a domestic agreement and is not enforceable at law. Now, why do you think this is this way? Because the intention of the parties was never to enter a legal relationship. Now, let's see the next essential element of a valid contract, that is, free consent. According to section 14, consent is said to be free when it is not caused by coercion, undue influence, fraud, misrepresentation, or mistake. To constitute a valid contract, the consent of both the parties should exist in the agreement. And moreover, it should be out of the free will of the person. Now, let's discuss each one in detail. Now, section 15 deals with coercion. Now, what is coercion? Coercion is committing or threatening to commit any act which is forbidden by the Indian Penal Code. For example, A threatens to shoot B if he doesn't sign the agreement to release him from a debt which he owes to B, and B releases A from the debt under this same threat. Since the release is due to coercion, such a release is not a valid contract. Now let's see what undue influence is. Section 16 deals with undue influence, where a person who is in a position to dominate the will of the another, we call it as undue influence. For example, for such influential relationships are an employer and an employee. An employer may be deemed to be having an authority over his employee. An income tax authority will also have an authority over the assessee. Similarly, a spiritual advisor over his devotee. Now let's see what fraud is. Section 17 deals with fraud. Fraud means any act or concealment of material facts with an intent to deceive another party. Misrepresentation is again unlawful. Now, when we say misrepresentation, it is about giving of inaccurate information by one party or their agent to another before the contract is made, and thereby they are induced to make a contract. The next is mistake of fact. Section 20 deals with mistake of fact. When both parties of a contract are under a mistake of fact essential to the agreement, such a mistake is what we call as bilateral mistake. And so, there is no contract at all. Hence, we can say that consent should be free from all these. The next essential element is competency of parties. The parties to an agreement must be competent to contract. That is, they must be capable of entering into a contract. If any party to the contract is not competent to contract, then it is invalid. Now the question arises as to who are competent to contract. Answer to this question is very simple. Every person is competent to contract who is of age of majority, who is of sound mind, and one who is not otherwise disqualified from contracting by any law to which it is subject to. Now let's see and discuss each of these in detail. What is the age of majority? A person domiciled in India will become a major when he or she completes the age of 18. However, age of majority shall be considered to be 21 years where a guardian has been appointed for the minor under Guardians and Wards Act. Any contract entered by a minor is void ab initio. Now let's take up an example for a better understanding. A very important leading case that explains the issue of minority is Mohari Bibi versus Dharmodas Ghosh. In this case, a minor had borrowed some money from a moneylender, and this was done by mortgaging his house. The moneylender moved to take possession of the minor's house when he defaulted payment. The court, however, said since an agreement with a minor is void, the moneylender could not enforce this contract. Now let's understand what a sound mind is. Section 12 of Indian Contract Act 1872 deals with this. A person is said to be of sound mind for the purpose of making a contract when he or she is capable of understanding and forming a rational judgment. An agreement with persons of unsound mind is void ab initio. Agreement with lunatic or insane persons. A person who cannot form a rational judgment due to some disease of brain and has some intervals of sound and unsound mind, during the interval he may enter into an agreement. For example, a patient in lunatic asylum who is at intervals of sound mind may contract during those intervals. Similarly, an agreement entered with a drunkard during the state of his unconsciousness is also void. A sane man who is delirious from fever or who is fully drunk that he cannot understand the terms and conditions of the contract or form a rational judgment as to its effect on his interest cannot contract while he or she is under such drunkenness or delirium. A convict, when undergoing imprisonment, is also incapable of entering into a contract. Agreements entered by insolvents are also void. Contracts with alien enemies during the state of war also stand void. Now that we have seen, let's go to the next essential element, that is lawful consideration. Let's first understand the word consideration. Consideration is quid pro quo, which means something in return. An agreement must be supported by consideration. Consideration means the benefit accruing to the parties. When two people enter into a contract, they have reciprocal benefits for each other. That is, one party gives something or does something for the other, and in return, the second party also gives something or does something for the first party. These benefits for both the parties are termed as consideration. It is the price paid by one party to buy the promise of the other. However, this price need not be always in the terms of money. For example, A agrees to sell his book to B for rupees 20. Here, A is getting 20 rupees as consideration, whereas for B, it is the book. The consideration can be in the form of money, it can be in the form of goods, services, or even a promise. The consideration may be an act, that is to do something, or it can be a furtherance, means not to do something. The consideration may be of past, present, or it may be of future. Consideration must be lawful and real. It must have some value in the eyes of law. However, the consideration need not be adequate. For example, if A sells his car worth 50,000 rupees to B for only 10,000 rupees, then this is a valid promise, provided the consent of A is free. Now let's see what the next essential element of a valid contract is. Another most important element of a valid contract is lawful object. The object and the consideration of an agreement is said to be unlawful when it is forbidden by the law, it is fraudulent, it involves injury to the person or a property, or when the court regards it as immoral, and also in case when it is opposed to the public policy. The object of the agreement must be lawful. An agreement made for any act which is prohibited by the law will not be considered as a valid contract. If the object is unlawful for any of the reasons mentioned under section 23, the agreement shall be void. Thus, the consideration as well as the object of the agreement should be lawful. For example, if Mr. A rents out his house for using it as a gambling den, the agreement is void, because the object of the agreement is unlawful. Now let's see few unlawful agreements. The very first one is objects which are forbidden by the law. Now let's discuss what are the objects which are forbidden by law. What does it mean? It means that which is not permitted by the law. Now let's take an example for this. Now if A promises to obtain from B an employment in a government office and B promises to pay A rupees 5,000, then is this a valid agreement? The answer is no. It is not a valid agreement because the object of the agreement is unlawful. Object which defeats the provisions of law. If the object of agreement is of nature that would defeat the provisions of any other law which is existing in the country, then such an object is unlawful and therefore such agreements are also void. For example, an agreement between the partners of a firm to conceal income in certain respects with an intention to evade tax is unlawful because it is against the provisions of Income Tax Act. Object involving injury to a person or a property of another is also a void agreement. For example, an agreement to pay some money for a crime is forbidden by law, and this also causes injury to a person. Hence, we call it as void. When the object is immoral, again, the agreement is deemed to be void. Let's take an example. For example, if A lends money to B on the condition that B divorces C and later get married to A, such an agreement is immoral and hence it is void. Now let's see what are the objects which are opposed to public policy. For example, agreements to the prejudice of state. Example, agreements which are interfering with the administration. Agreements which are interfering with justice. And also agreements which are in violation to the public policy. Now all these stand void. Now let's do a quick recap of what we have learned in today's class. According to Section 2H of Indian Contract Act 1872, a contract is an agreement enforceable by law. Hence, all the essential elements of a valid contract need to be present in the agreement. For example, there needs to be a legal offer and acceptance. There needs to be a legal relationship, a lawful consideration, competency of parties, free consent, and lawful object. In addition to these, there are certain requirements, there are certain formalities like it should be in writing, it should be in prescribed format, it should also be registered or attested, and also the requirement of having paid stamp duty. Now all these are very essential elements of a valid contract. In order to call a contract, all these are very important. However, absence of even one single element will make an agreement a void agreement, and hence it will be unenforceable by law. This is the reason we quote, all contracts are agreements, but all agreements are not contracts. That is, only those agreements which satisfy all the essentials of a valid contract can become a valid contract. One must be aware of all the provisions stated in law. Ignorance is no bliss in the eyes of law. Finally, I would like to quote the lines of Aristotle, educating mind without educating heart is no education at all. With this, I would like to conclude. Stay home, stay safe, and happy learning. Thank you.